Okay, so welcome to our Power of Attorney information event. So I'm Bethany from Crandon Springs Care Home in Wells, and I am joined with the lovely ladies Kat and Kate from Mogers Drewett.
Hello.
So they are going to run through a lovely Q&A for people that aren't sure in regards to power of attorney, any questions. So we've come up with some frequently asked questions, everything based around power of attorney. So we should be able to answer all your questions for you. So a little bit about Crandon Springs. We are a new residential and dementia care home within Wells. So we'll be opening in April 2021. So we have a couple of months yet, but we're trying to link with as many community groups and local businesses as possible. So I'll pass you over to Kate and Kat, who will tell you a little bit more about their day-to-day work, Mogers Drewett, and what they specialise in. Over to you, ladies.
Hi, I'm Kate Norris, working at Mogers Drewett, and I work within the later life support team, looking after managing our more older, vulnerable clients in their day-to-day living, also specialising in powers of attorney and deputyships.
And hi, I'm Kat King, and I work in our private client department, and I also specialise in powers of attorney, but also wills and probate matters. Thank you.
Lovely. So that gives you a little bit of a basic background. It's not going to be a particularly long video today. We wanted this so that you can click and share as often as you'd like to. So if there are any questions that arise, if you were looking for a recommendation in regards to power of attorney, just gives you a good idea as to what Kate and Kat get up to as a day-to-day. So together we have come up with 10 popular questions, which we hope answer all queries. But of course, if you have any questions, please contact the ladies on their details below. So we'll be sure to pass on their email address and number if you have any queries. But when you're ready, Kate and Kat, are you happy to jump in the questions?
Yep.
Lovely. Okay, so these are questions which we think will relate to potentially my clients here at Crandon Springs, but also anyone that is looking for more generic information in regards to power of attorney. So our first question is, what is a lasting power of attorney and why are they so important?
Well, the lasting powers of attorney is a document you prepare where you choose somebody to look after your affairs and make decisions for you, particularly in the future if you're not able to do so yourself. So it's very important for that very reason, someone you trust to make these decisions if you can't do so yourself. There are two types of documents, so one for property and finances, the other for health and welfare. So you sort of cover all angles, and the financial one, decisions such as paying bills, managing bank accounts and investments, selling and buying properties, health and welfare decisions such as day-to-day living, to more important decisions like life-sustaining treatment and where you live and who you live with. So you can see why these are so important. They're very important decisions that may be needed in the future, and you might not be able to make them yourself. I like to think of them like an insurance policy, so that you've insured your future life if you're not able to manage it yourself. You can make them, put them away, hope for them never be needed, but you've got peace of mind that if they're ready to be used.
Perfect. No, lovely. Thank you so much. So it's quite a large role then, really, isn't it? So you're taking quite a lot of responsibility, but it just is so important to make sure that it's in place.
Definitely.
Perfect. Okay. So my next question is, do I need a lasting power of attorney if I already have an enduring power of attorney?
So enduring powers of attorney used to be made some years ago, and if someone had made them, they're absolutely valid. However, there are some differences between those documents and what you can make now, so lasting powers of attorney, as Kate has just explained. So as I said, technically, yes, they're absolutely valid. However, they should be reviewed because the law changed about 2007. So that was quite a while ago. So someone may not perhaps remember exactly who they set up as their attorneys, whether they still are happy with the choice of the attorney. So it's always useful to review them just to make sure that that's the case. Another thing to bear in mind is that they only cover financial decisions. So as Kate explained, lasting powers of attorney and well, they now cover both financial and health and welfare. So it's possible to have, for example, an enduring power of attorney to cover your finances, but perhaps make a lasting power of attorney for health and welfare to cover that side of things. And another thing to bear in mind is that the way enduring powers of attorney are set up, they are not registered until they are needed, which is again a bit different to lasting powers of attorney. So there might be quite a long gap between when you want the powers of attorney to be used or when the attorneys can use them, because the registration process takes a really, really long time. At the moment, about even 12 weeks. So for example, I dealt with a couple who whose mother needed a power of attorney to sell the property. She only had the enduring power of attorney, and they had to wait 4 months for the documents to be registered with the court before they could actually sell on her behalf. So that's just something again to bear in mind. So
you almost want to be ultra prepared, really, don't you, and make sure that you've got all those documents in place before you have to. So okay, no, lovely. So my third question is, without a lasting power of attorney in place, can spouses, children, for example, or any chosen relative make decisions on my behalf if I'm not able to?
Well, that's a common misconception that a lot of clients, we discuss when they come to see us, and the short answer is no. They don't have a legal authority to access your bank accounts if you're not able to yourself. So, it's always important to have the documents in place to ensure that there is someone there that can legally access your bank accounts, your investments, buy and sell property if you're not able to do so yourself.
So I've got a good example. I, again, dealt with a son and daughter-in-law of an elderly gentleman who, it was great. He made a financial power of attorney, but he didn't make the health and welfare one because he believed that his son and daughter-in-law would be able to sort it out for him, where it turned out not to be the case. They unfortunately face a lot of difficulties where some of the doctors wouldn't talk to them, some of the carers wouldn't talk to them. So we tried to see if we could put that document in place. Unfortunately, the gentleman didn't have capacity anymore to put that in place. So they were left without being able to have the authority to do certain things. So perhaps do things that he would have wanted, which was a real shame.
Yeah, I think that's a quite a large misconception as well, isn't it? That you, as next of kin, I think you assume that you have automatic rights to that sort of thing. So at any
I think
age,
especially for spouses as well, they just assume that they can look after that, and vice versa. I think that's a real common misconception that we come across a lot.
Yeah, absolutely. No, thank you, ladies. So number 4, will I lose control of my affairs, as my attorneys will be able to take over and make decisions on my behalf, even if I still have capacity?
Short answer is no. Again, if you've got capacity, then you are calling the shots. You've put your attorneys in place to help and support you. It might be that your mobility is not great, so you're not able to get out and about to the bank and do things as you used to. Physically, you're finding it difficult. So then you would call upon your attorneys and say, I need your help. Can you do this bit of banking for me? Can you do this for me? So you are, you're still in control, but you're just asking for help. It might be that I've had clients that have just been inundated with paperwork and they just basically can't be bothered with it anymore. They just want someone to look after it, keep it all in order, and enjoy life a bit more. It's only when there's a lack of capacity that the role of an attorney changes, and that they are then acting for you because you can no longer do that. But the document's there to help you should it be needed.
Okay, so if your relationship breaks down, for example, there's no kind of opportunity there for it to be overpowered, the role, essentially.
No, and I think, and even if there is that lack of capacity, they always have to act in your best interest, and part of that is to take on board your previous wishes, your previous beliefs should always be considered, and also to involve you as much as you can in that decision-making process. So it might be that ultimately you've been deemed to lack capacity, but they can also involve that person in the decision as much as possible when making a choice for them.
Perfect. Okay, thank you. So number 5, should I instruct a lawyer to prepare my lasting power of attorneys, and is it a complicated process?
Yes, we would always advise to not just because obviously we are lawyers, to instruct a lawyer. We've already touched upon how important this decision is, how important the documents are. As part of that, we feel is to get the right advice and guidance. Lawyers can advise on clauses to put in the documents, which should be specific to your personal circumstances, something you would wish to consider putting in there. Your choice of attorneys, again, that's a very important decision. We would be able to provide guidance on that. There are ways, strict ways in which documents need to be prepared and dated and submitted to the Office of the Public Guardian. If that those haven't been followed correctly, the documents can be rejected. Then you're back to square one. It might mean doing the documents again, which would incur additional costs to resubmit the documents. If the documents were going to be challenged later on for validity, if it's been prepared by a solicitor, there's just that extra assurance there that it's all been done correctly. And making a power of attorney is a very important decision. So why would you not take guidance and advice on that to ensure that it's done right, and just take away the stress and burden from yourself of doing it?
Yeah, so I guess like a one-time thing, you want to make that decision properly.
Yeah,
and
and I think that if the documents need to be amended because they weren't done correctly, and they have to be cancelled and then resubmitted. It's not an easy process if you've done it and then think, oh, I didn't do that correctly, to then have to resubmit them later on.
Okay, no, thank you. So this is relevant to myself in particular, anyone younger. I think there's a misconception that actually you only need a power of attorney when you get to a certain age. So if I don't need a lasting power of attorney now, can I wait until I actually need them?
Not a good idea. As we never know what's around the corner. I think the last year has proved that, especially what tomorrow is going to bring. And if you have the documents in place, as long as you're over the age of 18, you can prepare a lasting power of attorney. They can be put away and hope they're never needed. But as I said before about an insurance policy, it's there in case it is. I myself have one. A lot of the misconception is that it's older age that need them. I've got one in case something happens to my husband, then won't have the stress and worry about dealing with it because the document would be there ready to be used. Another problem being that if you find you need one, it needs to be done quickly. As Kat explained earlier, the process of making and registering it is a few months. So, it's not something you can pick up and use straight away. And it's just, it's an important decision to make, and it can be risky leaving it to the last minute in case it's needed.
Perfect. So
yeah, and also just
like
to
say,
touch,
at any age then.
Yeah, and just to touch upon that, if you find you need one, but you've left it and then you're deemed to lack capacity, the alternative to having a power of attorney, just to touch upon that, is a lot more costly, time consuming and stressful for the family. It's a deputyship through the Court of Protection. So rather than it being your choice of attorney, someone that you've chosen, the court appoints somebody, so the court chooses for you. I had a case where a nephew wanted to be appointed for his aunt. We went through the process, but the court felt there was a conflict of interest within a trust that was already within the family. They then would only issue the order if a professional solicitor was appointed with the nephew, which we did, but that incurred additional costs of a deputyship when the aunt may have just appointed her nephew under a power of attorney, and there wouldn't have been we had to wait a year for the order, the cost of a deputyship. And the ongoing management through the courts is a lot of responsibility for that family member. And if the amount of times that clients have come in and said, oh, I wish mum had done that LPA, she was going to do it, never got round to it, because of the consequences that the family have found themselves in.
Perfect. No, okay, thank you, Kate. So question number 7, I have a will in place. Why do I need a lasting power of attorney?
So It's really important to understand the distinction between the two documents. So a will and power of attorney are completely two separate things, and sometimes they get confused. So to put it bluntly, a will is a document that comes into effect when you die. A lasting power of attorney is a document that you use in your lifetime, so that you've got someone to help you with your affairs if you can't, or as Kate explained, to take it over if you lack the ability to make your own decisions. But that's during your lifetime. So if you think about a time frame, so powers of attorney are used until someone passes, they then stop. At that point, they become invalid. And from there on, it's the will that takes effect. So that's why both documents are really important and both should be made.
Okay, perfect. And question 8 does touch on that as well. So can my attorneys access or change my will?
Technically, the answer is yes, although it's not very straightforward. So while you still have capacity, the attorneys can't access your will until you give them specific authority to do that. The law allows the attorneys to ask for a copy of your will if you lack capacity, although again, it may not be very easy because, for example, if solicitors hold the original will, they may question that may cause delays, etc. So it might be a good idea to, for example, let your attorney see a copy of your will or give them a copy of your will, say what's in your will, just so they know what you're planning on happening when someone passes. And attorneys cannot use the powers of attorney to change someone's will. So a lot of people are worried about that part, that attorneys will then, when someone loses capacity, they will go on and change their will. It's again, technically it's not possible. They can't do that. Although if there is something in a will that can be changed because it would be in your best interest, then yes, the attorneys can go to the court and arrange that, but it would be up to the court to decide if it's the right thing to do. And so a good example would be to, if you imagine that you wanted to leave someone, for example, some money that you have in a particular bank account, and you've put that in a will that money in this particular bank account should go to someone. And then you lose capacity, you didn't tell your attorneys about that, and they don't know. They might think that would be a nice idea to put your affairs into order, put everything into one bank account. They close that bank account because they don't know about that gift, and then the gift would fail when you die because the bank account wouldn't be there anymore, so that person would lose out. Whereas if your attorneys had access to your will, they would be able to see that you've gifted it to someone, that bank account, and they would leave it alone, unless obviously it was specifically needed for example, paying for care fees, etc. So that just, I think, illustrates how important it is to at least consider whether it would be a good idea for the attorneys to see a will. But the short answer is no, they can't. They can't change anything in the will.
So a lot of it comes down to organisation for peace of mind, really,
Yes.
doesn't it? So, okay, no, lovely. So question 9 and 10, we wanted to focus on the sale of properties. For a lot of people, it's the most expensive asset that they have. When you're considering moving into a care home, a lot of people will need to sell their properties. So we've based the last 2 questions on assets and property. So is it a good idea to transfer the house to my children while I still have the capacity to do so?
And again, I think we gave quite a lot of no answers. Again, the short answer would be no. Although on the face of it, it does sound like a really good idea. Unfortunately, it has a lot of consequences that would need to be considered to make sure it's an informed choice. It has a lot of tax implications, so both for inheritance tax, capital gains tax. I'm not going to get into details of that because it is quite a complex area. But of course, if anyone has any more specific questions about that, would be happy to answer that. But that's one thing to bear in mind. Another would be that by gifting your house or giving it to someone, say your child, you lose the control over the property. So imagine your relationship with the child breaks down, or if they were to predecease you, then the house that you gave them belongs to their own beneficiaries, and they might force a sale, and then you would lose your main asset.
So you almost become a tenant then, really, Kat, is that
exactly.
right?
Yeah, exactly. But you might also be forced to move out because they might not want you to be there, and of course you then lose the ability to, as I said, have the control over what happens with that property, with that asset. And finally, the child might get divorced, or they might become bankrupt, and then the share of the property, or the whole of the property, if that's what you gave them, it would be taken into account in financial proceedings for that child. So again, we've got the same scenario where you potentially would be forced to move out. And finally, it could be also seen as a deliberate deprivation of assets. So the social services, when they check the eligibility for care funding, they can look at assets that you have in your sole name, and they can also look back as to what you perhaps have given away, and they could potentially claw that house back if they believe that you gave it away with the intention of not being able to have this asset as part of calculation for care funding. So there's no time limit into how far back they can go. So just to sum up, the idea sounds good, but the reality is that it tends not to be.
Yeah. No, lovely. Okay, thank you. And the last question is very similar, but how can I protect my largest assets in my house for the next generation?
So the short answer here would be to put a trust in place. So imagine you've got a married couple. You could arrange so you hold the property, so which again, as we said, tends to be the main asset. So you would arrange for it to be held by the married couple as 50-50, so each of them has their own half share. And then they could put a life interest trust in their wills, either with regards to everything that they have, including cash, or it could be just with regard to the property. So let's focus just on this second scenario. And then imagine that one of that married couple dies. So their half share of the property would be put into this life interest trust, so this trust bubble. Then that means that that half of the asset is protected, because the surviving spouse can have the enjoyment of the property, so they can remain living there. They would, of course, need to pay maintenance, pay the bills, etc., as they would if they own the whole property. However, they would only own in their sole name their own half share of the property. So say they then need care. The local authority social services would be able to look at what they hold in their sole name, but they wouldn't be able to take into account that other half that is left on trust. And this applies also to not only that, but also imagine you have a couple who have children from previous relationships, or they are worried that their surviving spouse might remarry and then leave the property to someone else. So again, we've got the same layer of protection. And also if someone, so the second spouse of the married couple, if they have to move into care and their property is sold, then the half share that is held in trust, or was held in trust within the property, that would then be still held on trust, but in terms of the sale proceeds. So when the property is sold, the surviving spouse has their own half, they have their own half, and they can do whatever they want with it. So for example, use it to pay for the care, whereas the half that belonged to the first of the married couple to die would still be protected within that investment, and the surviving spouse would be entitled to any interest produced by that investment. But again, the capital, so that protective bubble, would still be in place during their lifetime, and then would come to an end when the second person also dies, and then would be distributed in accordance with the will of the first spouse. So we've got the layer of protection throughout the whole process, regardless of whether or not there is a property.
Perfect. Okay, thank you very much. So that comes to the end of our 10 questions. So I feel like I need to go and get a power of attorney now.
I think you should. You know where to come.
Yeah, I know, lovely ladies. But I hope for obviously the people that are watching this webinar at a later date, we've been able to, in 10 minutes, kind of give you a very brief outline as to how Kat and Kate will be able to support people that are looking at lasting power of attorneys. wherever this webinar is shared to, whether that is Mogers Drewett website or Crandon Springs, we will ensure that both details are shared on there. So if there's any further contacts that you need or any questions that are raised, you are able to answer that. But thank you so much, Kate and Kat. You have answered the questions beautifully. Did you have anything you wanted to add to the webinar at all?
Just to say that if there are any questions, you know, please do give us a call or email us. We're here to help and answer any queries you may have.
Perfect.
Yeah, we appreciate we sort of talked a lot about various aspects. So if anyone has more specific questions, or as Kate said, anything we can answer, just contact us and we'll be very happy to help.
Lovely. And they really are an amazing team. They're very highly regarded. So please get in contact. And of course, Crandon Springs will be opening in April 2021 to new residents. So it'll be a really exciting time. Thank you so much.
Thank you. Bye-bye.
Cheers. Bye.
Bye.